Thank you also to Clearline Recruitment, who have helped us put this on. Just a quick shout out to Clearline Recruitment. They're an established recruitment agency based in Brighton with 20 years experience. I know most of you will probably be familiar with Rix Kay, but a quick overview of us. We're a full service law firm with offices across Sussex in Brighton and Hove and Uckfield, and also out into Kent with offices in Sevenoaks and Ashford. Full service law firm, like I said, offering the full services of legal expertise to businesses, and also a full service private client offering, so providing services to business owners, managers and their families. Within that, we have obviously a full service employment law offering, and I'll hand over to Amy in a moment, who will take you through the session. Within that, we also have a well-established employment law retainer offering called Gatekeeper HR. We've just launched a brand new website for our Gatekeeper HR platform, and you can take a look at that at www.gatekeeperhr.co.uk. Details of that will be on the screen at the end. Just a little bit of housekeeping before we get going. The session is being recorded, and we will make the session available to everyone afterwards, which will be on our website. We will do a Q&A as well, so if you have questions during the session, then please just use the chat function and we'll pick those up at the end. We'll do all the Q&A at the end. Or if you want to just ask on the live session, then please just unmute yourself and we can pick those up. Please also, if you could just keep yourself on mute during the whole session, that would be much appreciated. Okay, I don't think there's anything else from me. I'm now going to hand over to Amy.
Thank you very much, Scott, and good morning, everybody. Thank you for joining us today. I think my slides have slightly gone to sleep. Let's see if we can move them along. I was just going to do a little bit of introduction to myself. Here we go. Some of you will know me, some of you I don't know. So I'm a solicitor and a partner with Rix Kay. My specialism is employment, and I sit within that employment department that Scott's just referred to, advising businesses but also individuals on their employment rights and best practice. And I also manage that external retainer service, Gatekeeper HR, and I'm a member of the firm's management team. We've got quite a lot to get through today. We're going to look at the Coronavirus Job Retention Scheme, because we are allegedly approaching the end of it. We've heard that before, we'll see. We're going to touch on the new normal, because I get the very clear impression that people are hoping for a return to the office or the workplace in the near future, and we'll have a look at how that might be possible. We're going to think about changing terms and conditions of employment, which is something some employers may be having to consider, along with redundancy and how we might go about that fairly, or the circumstances in which that can take place. And we'll end on a high note after the talk of redundancy by looking at the Kickstarter scheme and apprenticeships, which are a key focus of the government's recovery programme. As I say, a lot to get through, so we will kick off straight away. With the Coronavirus Job Retention Scheme. I'm sure you're all really familiar with this by now. It was introduced on Friday the 20th of March, very shortly before we were plunged into our first lockdown. And the intention behind the scheme was to help employers whose operations have been severely affected by COVID-19 to retain their staff, and in turn to protect the UK economy from swathes of business closure and high unemployment. Amazingly, the scheme was only initially due to run between the 1st of March and the 31st of May. But as we know, things didn't quite go to plan, and the scheme was modified and extended repeatedly, and is now due to end on the 30th of September this year. I would suggest that remains dependent on the success of the government's recovery programme. There's a lot of factors to take into account. So it is a case of waiting, watching and seeing, but that is the end date that we have at the moment, and the end date that businesses and business owners, of course, have worked to. What the Coronavirus Job Retention Scheme did was introduce the concept of furlough leave, something that we're all now really familiar with, we know inside out. But when it was introduced, it was an entirely new concept to employment law. It was a fascinating time for employment lawyers like me trying to get to grips with an entirely new concept that hadn't existed before. But essentially what it meant was that employers who were negatively impacted by COVID could send home their staff without work, and the government would pay 80% of their wages for the non-worked time, up to a monthly cap that I've indicated on the slide there. Employers had the option to top up that government funding, but weren't obliged to. And in terms of my clients, I had a mix, some that could afford to, perhaps temporarily, others that it was just not viable because of the nature of the impact COVID had on their business operation and their income. Later down the line, we saw the introduction of flexible furlough. What this did was allow businesses where some work was available, but not enough work to fill an employee's entire normal working hours, to allow the employee to work the time they had available and the employer to pay them for that as normal, but then to be furloughed for the remainder of their normal working hours and to receive furlough pay for that period. So a phased return, really, trying to get people back to work where some work's available, but not the usual amount. The scheme now is winding down. Up till the 30th of June, nothing changes. So you can continue claiming your 80% up to that £2,500 cap per month per employee who is furloughed. But from the 1st of July, we will see changes. The contribution that the government will make reduces. So the government will contribute 70%, the employer has to top up or add the remaining 10%. And from the 1st of August and then through August and September, that contribution from government will be 60% and the employer will be responsible for the remaining 20%. So we can see that the employee throughout is protected, receives that minimum 80% up to the normal cap, but the amount the employer is contributing gradually in a tapered way is increased up. And of course, the employer remains responsible for NI and pension contributions. In terms of employer eligibility, this is something that's remained vaguely consistent throughout, but of course the reference dates have changed as the scheme has continued to be extended. So for claims that are being considered at the moment, realistically those beginning on or after the 1st of May, you need to have started a PAYE payroll scheme on or before the 2nd of March 2021. You need to be online enrolled for PAYE, possess a UK Isle of Man or Channel Island bank account. And really that opens up the scheme to a wide range of employers, limited companies and businesses, charities as well. Generally, public sector employers are excluded, as are non-public sector employers who receive funding, public funding for staff costs, the idea being the government shouldn't be giving double the funding to that employer. And it's important that an employer who is trying to access funding under the scheme takes the right steps with regard to its employees that it wishes to furlough, i.e. it designates them as furloughed, it enters into a written agreement confirming that designation and it retains that for 5 years. We know that HMRC will audit businesses who have relied on the furlough scheme and they'll want to see those agreements on record. So be sure to have them, maybe check that they are still all in place and up to date and make sure your retention periods are in line with that guidance. In terms of employee eligibility, again, this varies because the scheme has been extended a few times. So for claims starting on or after the 1st of May, the employed date that we look at, the reference date, is the 2nd of March 2021. Throughout, there's been little guidance provided as to how we select for furlough, and that remains the case. Our guidance has generally been to our clients to at least put together some form of rough and ready selection matrix that is entirely focused on business need. Where has your business been negatively impacted? Where do you not have the facility to provide work to your staff? That will help if ever there were any suggestion that the decisions you made around who to furlough and who to keep working were in any way discriminatory. So it's sensible to jot down your thoughts in that regard and keep them again on record. So employees can be furloughed irrespective really of the nature of their engagement. They can be full-time or part-time, permanent or indefinite contracts or fixed-term contracts, and even 0 hours staff. And the definition that the job retention scheme uses of employee is a lot wider than our traditional definition of employee in the other bits of employment legislation. Office holders are covered, agency workers, casual workers, LLP members. So for example, a director who works in your business, an executive director, can be furloughed if they are salaried. The decision to furlough them is adopted as a formal decision of the board, and that decision is recorded and kept. And during their period of furlough leave, they don't do any work for you in their employed capacity, and they only carry out really limited statutory duties that are essential, such as, for example, filing accounts if that's one of their duties. Obviously, the amount of money they would receive by way of furlough is limited to that salary. It wouldn't include anything they get under their shareholder role, for example. That's an entirely separate capacity. And similarly, apprentices can be furloughed, and apprenticeship training can continue. But again, just make sure any apprentice that is furloughed that does training is getting at least the national minimum wage for the hours that they spend training. Again, I'm sure this is all stuff you're very, very familiar with, and I'm preaching to converted here, but it's good to just refresh our memories about the scheme and its requirements. It's been clear throughout that employees cannot work for their employer whilst furloughed. They can, however, undertake training. They can work for another employer, subject to their contract, which may, for example, say that they need to get the primary employer's consent. And they can volunteer, but of course not for their primary employer, because that would circumvent the purpose of the scheme. If they've got more than one job, an employee can be furloughed from both jobs because each one is treated separately. And they can take holiday whilst on furlough leave. That's something that at the outset of the scheme, there was huge confusion about. There was limited guidance to begin with. We did finally get some clarity. We know that employees can take holiday during furlough leave, whether they ask for it or more likely the employer indicates that they need to take it. If an employer wants an employee to take holiday whilst on furlough leave, they should give proper notice, which will be a minimum of double the notice as the length of leave the employer wants the employee to take. And bear in mind that any holiday taken during furlough leave must be paid in full. So whilst there will be a contribution from furlough pay, the employer will be responsible for topping up to 100% of normal earnings for any days treated as holiday. It is, however, even though there is that additional cost, obviously very sensible to get employees to take holiday whilst on furlough because of the government contribution, but also so that you don't end up with, and I do know some businesses where this is happening, with everybody coming back to work post furlough leave with 30 odd days holiday accrued in the bank ready to take. So it's very sensible to try and stagger that and make sure people are using some holiday up whilst furloughed. Furlough is not intended for those who are self-isolated or on short-term sick leave. They, of course, would be eligible for SSP. If it's COVID related, that's payable from day 1 instead of the usual day 4. And an employer may then be able to claim 14 days of SSP back via the Ssp Rebate Scheme. If, however, an employee becomes sick whilst they are furloughed, then the government has left it to the employer's discretion to decide whether to keep them on furlough or move them to SSP. So that's a decision for you. Shielding, you may well be aware, was paused nationally from the 31st of March 2021. There were provisions in the Coronavirus Job Retention Scheme related to those who were shielding, also to those who had childcare issues arising from school closures. They, of course, haven't been changed, but don't apply in the same way now that shielding has been paused and schools are reopened. And as the slide says there, those who are clinically extremely vulnerable and can't work from home, and that's the important bit, are now advised to attend their workplace rather than to continue shielding. And so, given the scheme is due to end on the 30th of September, we will be thinking about ending furlough leave in many businesses over the next few weeks and months. Irrespective of when that final endpoint might come, it's always sensible to review your furlough arrangements to check whether anybody can be returned, whether that's full-time or on flexi furlough. If a return's not viable immediately, checking that your agreements are up to date, that any extension to furlough is confirmed in writing and recorded. But if you are able to end someone's furlough leave, thinking about the notice that you give that employee. There's no minimum notice period specified in the Coronavirus Job Retention Scheme, but we know in employment law that the key principle through most things is to be reasonable as an employer. So you want to tell staff with as much notice as possible that you are going to end their furlough leave and return them to work. And you want to give them an open forum to raise concerns that they might have, because it's important to remember that some staff may have been furloughed for almost 12 months, that a return to work will seem very daunting, that they may have worries, and that they will want to have a bit of support in that regard. Also note that if, and obviously we'll look at terminations down the line, but if actually somebody who's been furloughed can't be returned to work, their employment has to be brought to an end, bear in mind that since the end of last year, you can't use furlough pay to contribute to notice pay. That has to come from your own pocket now. So that is a change that came in at the end of last year and requires the employer to fund 100% of the notice rather than, as in the past, only the 20% top up. So that's the Coronavirus Job Retention Scheme. I'm sure a lot of that was familiar to you, so apologies if it seems like repetition, but I think it's useful to just refresh where we're at. Because we are now approaching a situation where things are beginning to ease up and change, and you'll have heard the phrase the new normal. I'm sure it's a bit of a buzzword at the moment, but it is sensible to think about what a return to normality might look like for employers and employees. With effect from the 29th of March, it's no longer a criminal offence to leave home to go to the office, even if your job can be done from home. That has been eased, which is useful. That said, of course, the guidance remains to say that if you can work from home, you should do so until at least the 21st of June, which is stage 4 of the government's roadmap. Unless, and there are some caveats to this, home working is not appropriate, and there might be various reasons why that's become the case. It could be you can no longer do your job effectively from home. Perhaps there's been a change with the employer, with your operation. But it could also be more personal to the employee. It might be a challenging home working environment. Perhaps that's to do with children and childcare, or it could be to do with mental and physical health difficulties. We know that isolation at home does impose a lot of pressures, and that could be having a detrimental effect on an employee such that a return to the office is now appropriate. I know from speaking to my employer clients that many are very keen to recommence normal operations, and I completely understand why that is. But of course, we have to caution and say it can't be rushed. And if you are going to do that and you can justify doing that, then it needs to be done in line with government guidance. The key thing is, of course, to prevent or reduce at least the risk of transmission. And I've put some examples there of what employers can do in that regard. Providing antibacterial hand wash, introducing one-way systems, staggering start and end times, of course, observing social distancing. And before any return to work, a key thing to do is to complete a secure workplace risk assessment, because that will then allow you to identify the means and measures you can introduce to help keep people safe, to identify the hazards and reduce any risks arising. Some employees, even if the employer is keen to recommence normal operations, will be very wary of coming back to work. As I say, some have been at home for a long time, and some may have some very legitimate health and safety concerns. In that regard, if somebody can work effectively from home, realistically, they should be permitted to continue to do that, given the current guidance that we have that says 21st of June is really the first point at which we should be thinking about a return to the office. And if they can't work from home, even in that scenario, can we give consideration to whether they could be redeployed to a remote working role before moving on to any other formal procedures? And the reason I say that is because dismissals relating to the raising of health and safety concerns can be deemed automatically unfair. So it's very important to take a cautious approach, think things through and take them step by step. I would suggest that if you have people raising concerns about returning to the office based on health and safety issues, it would be very sensible to take advice. It might be, however, that an employee doesn't necessarily have particular health and safety concerns, but they just feel generally very anxious about returning. And I think, as I say, that is understandable given what's happened in the last 12 months. And so an employer should be sympathetic to those and see if they can have some dialogue with that employee. Maybe be creative, see if there's ways that you can make the employee more comfortable and ease their return to work, perhaps flexible working in the initial period. Maybe actually if a return immediately is too overwhelming, can they take some unpaid leave or use up some of their holiday? Maybe you could help them with the journey to work. Maybe they're worried about public transport, so you can provide car parking so that they can drive, or maybe you can stagger their start time so they're not travelling at peak time. Of course, bear in mind that depending on the severity of the anxiety they're experiencing, they may be signed off on sick leave and then entitled to SSP. And at the very upper end, it may amount to a disability under the Equality Act, so just keep that in mind. In the alternative, of course, there are lots of employers out there who are completely comfortable continuing with home working and think actually it's been a complete revelation and will help them reduce all their overheads and answer all their prayers. But even those employers, unfortunately, can't relax too much. That's what the employment law would say, isn't it? Realistically, they need to be taking every step they can to facilitate home working, so reviewing the resources and equipment people need and making sure that everybody's got what they need to work efficiently and safely from home. And in that regard, carrying out a risk assessment connected with home working is very important. You want to identify hazards, assess risks, just as you're doing if you're returning people to the workplace. Very important is to consider the impact of continued home working on staff well-being and provide support. As I say, if you're someone who's been working at home for 12 months, perhaps you live alone and you have limited contact with colleagues because of the nature of your role, that's a hugely isolating experience. And we need to just ensure that we are looking after our staff and their welfare. We have a duty of care to them. So assessing the continued impact of ongoing home working is important. And also very significant is ensuring you give thought to the protection of confidential information and compliance with data protection law during home working, because that really does present risks. Are we complying with data protection law in the way that our staff are working from home? Are they protecting our personal data, or is it being exposed to risks it wasn't exposed to during office working? And also, is the home working situation exposing you as the employer to risks of your confidential information being mistreated by even your staff. So perhaps now that the dust has settled with the home working situation, if you are intending to continue with that arrangement, now is a good time to have a think about what measures you can put in place, what protections you might need. So irrespective of whether it's a return to work or just a continuation of home working that you're planning on putting in place, the key thing is, of course, always to communicate with the staff, make sure they know where they stand. You could send regular updates, you could arrange Q&As with management, you might even undertake a staff survey. My firm has done that, and it's a great way of identifying where there are points of concern and making sure whatever steps you're taking are targeted and tackling the correct issues. But of course, it may be that just sort of continuing with the current arrangement or returning to work as before, that neither of those options are viable for you. That actually the impact of COVID has been such that you need to make more significant changes. And that might involve considering whether terms are changed for your staff. An employer is only going to be permitted to change an employee's terms in two situations. Firstly, if their contract permits that change, or if the employee expressly agrees to it. I would just say that during this part of the session, I'm not going to deal with collective consultation. That's too big an issue for a brief webinar of this nature. But if, of course, you are collectively consulting with numerous people in connection with changes of terms or potential dismissals, do take some specific advice. So if you have a contract that does allow for a change of terms, it will no doubt be called a flexibility clause. And what it might do is say that you can slightly vary where somebody works from, for example, change their place of work. But just because that clause is contained in a contract doesn't mean you're off the hook. You have to check that clause, see what it specifically allows you to do or change, check whether notice provisions are included, how you give notice, how long that notice needs to be, and whether there's any process that you need to follow. Because just because that flexibility clause exists, if you don't follow the terms of that clause, you may still be in breach. And of course, even if there is a flexibility clause that allows you to make the change you need to make, you must behave reasonably in the way you implement that change. But if you don't have a flexibility clause that allows you to make the change you need to make, and that will be the case for many employers, then you must get your employees' consent before you make the change. Because if you just simply decide as the employer unilaterally that you're making that change, everybody's subject to it and hard luck, you certainly could be exposing yourself to a variety of employment claims, breach of contract, constructive unfair dismissal if somebody feels the change is so fundamental they are entitled to resign and treat themselves as dismissed. Of course, context is everything, and the surrounding circumstances will heavily influence how an employee responds, and that's something that's worth bearing in mind in the current climate. I've put a note on the slide there about consideration. There are some changes of terms that if we wanted to make them, we would effectively want to offer the employee a bargaining chip in exchange. If we want to make somebody subject to restrictive covenants where they haven't previously been, we might want to think about giving them a pay rise, whether a bonus is suitable at that point in time, so that there's a bargain and some consideration passing between employer and employee in respect of that new term. Again, quite a niche point, and if you were varying contracts in that way, worth speaking with a solicitor before doing so. The key thing, if you are seeking consent from your staff to change terms, is to consult, and that goes for lots of employment law, but particularly in this situation. You want to speak with your staff and explain the situation you're in, and you want to give them an opportunity to raise concerns and ask questions. And while under normal circumstances, an employee might quite understandably not be terribly inclined to agree a reduction in their pay or a reduction in their working hours, if the alternative is business closure or job losses, and they're well aware that that is maybe an industry issue or even a national issue, then there may be more of an appetite to compromise and reach some form of agreement. I have put a note there to say beware duress. Of course, what we don't want to do is be saying to people, accept this pay cut or I'll sack you. That's absolutely not the route that we will be taking. We cannot seek agreement by duress, and it wouldn't be valid anyway because it wouldn't have been voluntary. But of course, being honest with staff is also key. So the suggested approach is to weigh up what it is you're trying to achieve and whether a variation to terms helps you get there. Are there any alternatives? Because if there are, maybe try them first. Go through the process of analysis. If changing terms is the viable option, meet with your staff and be honest with them. Set out the situation the business is in, the problems it's facing, and why you are proposing this change of terms and how you believe it will help your business, so that they're fully informed, they understand the picture. Then allow the employees time to consult with you, have an open door policy. They can ask questions, queries, make representations. You might even want to see if they've got any ideas, because often they might suggest something that you've not even thought of, and that can be very useful. Depending on the nature of the change, it might be that you might ask for volunteers, because some changes will suit some staff and not others. It might be that you only need a handful to agree for it to be workable. You might offer incentives. I appreciate probably not financial incentives, but there are other things we can do, other creative ways we can incentivize. And it might be that you adopt some of the ideas that the employees have put forward to show compromise, but also that your mind wasn't made up when you entered into this dialogue, that actually you went into it open-minded, willing to listen, and that it has been a very genuine consultation. If changes are agreed, whilst the law says technically they don't always need to be agreed in writing, you would always want to put them in writing. You don't want future misunderstandings, you want clarity, particularly if the change relates to pay. And of course, if it's a Section 1 term, then it must be put in writing in any event. The key, of course, and which everyone will be wondering about, is what happens if they're not agreed. I would say take as long as possible, or as long as you're able to talk with your staff to try and reach a compromise. But sometimes it's just not going anywhere, and you then have some difficult decisions to make. One option is imposing the change without agreement. Some staff may just accept it and continue with no real issue, but you may find that others work under protest, or even, depending on the term you've changed, resign and claim constructive dismissal, as I said. So again, if that's the situation you're finding yourself in or approaching, definitely take some advice. And the alternative is dismissing staff and offering them re-engagement under the contract containing the new proposed terms. Should be a last resort. Of course, because it involves a dismissal, can result in claims, and you should certainly be taking advice before doing anything of that nature. We move on to redundancy now, because actually a proposal to change terms and conditions is often something that is put forward as an alternative to redundancy before a redundancy procedure gets going. In advance of commencing a redundancy procedure, an employer should be thinking about all the alternatives that are available that they might be able to engage with or use to avoid having to make redundancies. So changing terms and conditions might be one of those alternatives, but so too will imposing a recruitment freeze, stopping using contractors, offering sabbaticals, offering voluntary redundancy, redeploying staff, etc. But of course, in some situations, there aren't any alternatives. Redundancy is really the only viable or workable option that an employer has. And at that point, they really need to make sure they have a genuine redundancy situation. It might be one of three situations. You might be closing your entire operation, business closure. You might be closing a branch or a particular establishment of your operation, which is a workplace closure. Or it might simply be the case that you've got a reduced requirement for staff to do a particular type of work, whether that's because you've lost a contract, so you have less work for your existing staff to do, or you've restructured, you've improved efficiencies, you've introduced new technology that means you need fewer people to do the same amount of work, essentially. So long as you've got a genuine redundancy situation in line with one of those three, the process that you engage with is a consultation process, and starting that early is going to be very important, and then engaging with it fairly and genuinely too. Again, I'm not going to touch here on collective consultation where redundancy is concerned. That's with the bigger numbers. If you are at risk of making many more people redundant, if that's the situation you're in, do take specific advice. With smaller numbers, there's no statutory procedure that you need to follow in terms of sort of ticking through a procedure. There's obviously case law and ACAS guidance, but you may find you've got a contractual process. So check contracts, check any handbook to see if a contractual procedure has snuck in there. Because again, if you don't follow that, you could find that you are accused of breaching any such policy or procedure or even a contract. But the key principles of a redundancy procedure are fairly straightforward, actually, and you'll probably be familiar with them. You need to warn and consult your staff. That goes back to starting early, being honest with them, explaining the situation you're in, and that redundancies are now having to be considered. And then keep that consultation going throughout. We don't just do it at the outset and then forget about it. We need to have that ongoing communication with the staff that are affected. We then need to adopt a fair basis on which to select for redundancy. So we select a pool, i.e. which area of staff are affected by this reduction in workload, say, who will we be selecting for redundancy from? And then we need to adopt proper and objective selection criteria from which to select those who are potentially redundant from the pool. So don't use highly subjective criteria like culture fit. Think about things that are measurable, attendance records, disciplinary records, qualifications. And finally, we need to think about suitable alternative employment. We need to look for it, and if it's available, we need to offer it. In terms of entitlements, just a brief rundown. A redundant employee is entitled to time off or reasonable time off during working hours to look for work or arrange future training for future employment. If they've got 2 years or more service, they're entitled to a redundancy payment. And I would always recommend you check out the government calculator to calculate redundancy payments. It's very straightforward, very intuitive. And they're also entitled to their full contractual notice. Bear in mind, it can't be spent on furlough leave, as I just said. And also a payment in lieu of any outstanding accrued holiday, unless, of course, they take that during their notice. Hopefully, of course, for most of us, redundancies will be avoidable. That's the ideal situation. And the government's doing a lot to try and help employers ensure that that is the case. It's introduced various measures to support employers to retain jobs and to avoid terminations. The Ssp Rebate Scheme in connection with absence through coronavirus, business rates holidays, interruption loans, grants in connection with businesses that were forced to close, etc. But a newer scheme is the Kickstart scheme, which is a job creation scheme established for young people on universal credit aged 16 to 24 who are at risk of long-term unemployment. The scheme opened on the 2nd of September. After some teething issues, chops and changes, employers can now apply directly to the scheme for any number of placements. They can go through a Kickstart gateway, but they don't have to. All employers are eligible for the scheme, regardless of their size, but they can only access funding for a job placement for a 16 to 24-year-old at risk of long-term unemployment if it's a new role. So you can't replace an existing or future vacancy and then apply for funding. You can't cause an existing employee or contractor to lose their job and then engage somebody under the Kickstart scheme to replace them. If you're seeking funding for the role must be for 25 hours per week as a minimum and for 6 months at least. And it shouldn't require the employee to undergo extensive training before they start, partially because part of the purpose of the Kickstart scheme is to train people on the job. If you are going to engage anybody under the Kickstart scheme, you want a fixed term contract and limiting the employment to at least the initial 6 months. Of course, what happens after that, you might find that they're fantastic and you want to keep them in your staff. But if you want to use the Kickstart scheme for the initial 6 month period only, make sure the contract's correct in that regard. In your application, you want to set out how the placement that you're putting forward for funding is going to help that 16 to 24-year-old develop skills, whether that's to do with CVs or interview technique, but also workplace skills, attendance, timekeeping, etc. The employee must be paid the national minimum wage for their age group, and funding's available for 100% of that for 25 hours a week, plus NI and employer contributions. Again, you can top up, but you don't have to. And there's also a grant for setup costs. And in addition to the Kickstart scheme, apprenticeships have obviously been in place for some time now. I'm sure lots of you are very familiar with them, maybe already use them. They're available to all age groups above 16 at various levels, often for a fixed term, whether that's a set number of years or just until somebody reaches a particular qualification. Again, there are national minimum wage rates that apply to apprentices, and the training element is usually funded or at least partially funded by government. But there's certainly been a renewed focus on apprenticeships in light of COVID-19. The government really wants to ensure that apprenticeships are available or an option for as many potential apprentices as possible. So any new apprenticeships commencing between the 1st of April and the 30th of September this year will be supported by a bonus payment, and that's in addition to existing funding that's available. And the government is also introducing a £7 million fund from July of this year with the intention of helping employers in England set up and expand portable apprenticeships, which we'll get more information about down the line. But I think it's just a sign that apprenticeships are big business for government at the moment. It's something that they're very much behind and will support businesses to provide. One thing to note, and this is where the legal side really does come in, is that when you are taking on an apprentice, it's vital to get the contract type right. the Apprenticeship Skills, Children and Learning Act 2009 introduced the concept of an approved English apprenticeship in England. It requires an employee to complete an approved apprenticeship standard, and that will relate to the industry that they are working within. But what that does is require an apprentice to be engaged under an English approved apprenticeship agreement, because that ensures they are treated as an employee and have the same rights and entitlements as your other employees. If you don't engage them under that type of agreement and instead accidentally engage them under a contract of apprenticeship, the old-fashioned type, then you may find that actually the core or primary purpose of their engagement is training instead of work for the employer, work for you. And in turn, that may entitle them to damages if they were dismissed during their apprenticeship, for loss of earnings and training for the remainder of their apprenticeship term, which could be years, depending on when you dismiss them, and also potentially loss of future career prospects. So this is a really key thing to note and to get right. Making sure you have the appropriate apprenticeship agreement in place can be really, really important if you are unfortunately having to dismiss an apprentice during their apprenticeship. And that, dear friends, is the end of my session today. It has been a bit of a rattle through, so I'm sorry if there's been a lot covered and a lot to keep up with. But I think there's so much going on at the moment as a result of COVID-19. There's loads more we could have covered, but hopefully those are some key things that you might be mulling over at present. And I've just put my standard disclaimer there, as I have to as a lawyer. So thank you very much for listening. I'll hand over to Scott.
Thanks, Amy. That was really good, and I hope everyone on the call was able to take something from that, and it was useful. We've not had any questions on the chat function. Does anyone have any questions for Amy? We're happy to pick those up. If you do, then just take yourself off mute and fire away.
Hello. Good morning.
Morning, Louise.
Hi, Amy. Thanks ever so much. That was fabulous. Lovely to have the reinforcement of all the good stuff that's been going on. So thank you. Just a very quick question on the apprenticeship. I just want to make sure I'm super clear. We have 2 apprentices. Our second one joined us yesterday through Clearline and Next Step, which is absolutely wonderful. But we put them on our normal contract of employment with a fixed term. So they're just, as far as I'm concerned, they're a member of the team, they're a member of the staff, they get every benefit that everybody else does. That is completely correct, yeah?
Yeah, that's a very sensible way to go about it. If I'm preparing apprenticeship agreements, I tend to base them on an employment contract. I might add some extra bits in to reflect the fact that they are undertaking training, that they have obligations to go to their college sessions and exams and things like that. But yes, they are to be treated as an employee rather than that other area where the training is the primary focus. So that's absolutely right. Yeah.
Fabulous. Thank you so much.
No problem.
Thanks, Louise. Does anyone else have any questions for Amy at all? If you do, take yourself off mute.
Hello guys, Chris Wellings from Southdown Housing Association. I'm interested in terms of managing people back into the workplace and vaccinations, and a lot of debate going on around people who are vaccinated against those who are not vaccinated, but people refusing to work with people when they know they're not vaccinated.
Yeah, so really, it's an absolute minefield, actually. And we've been engaging with different commentators and different training that's being offered by barristers and the like, because it throws up such a huge number of issues, whether it's to do with religious discrimination. You know, people may not engage with the vaccination program because of religious views and how that then plays out. I've been asked repeatedly whether employers are permitted to prevent staff returning to the office if they've not been vaccinated. And at this stage, certainly, our suggestion would be not. I think the best position to get yourself to is a position of communication. So where you are communicating to the staff about vaccination if you think it's something that would be useful, if there are health and safety issues in the manner in which you work, but then engaging with those that maybe have reservations about it and getting a better understanding of what those reservations are. It's not, I don't think it's going to be a one-size-fits-all solution, I'm afraid, because there will be different reasons for objections or people not being able even to have the vaccination. So yeah, a minefield, I think, and one to approach with caution and on a case-by-case basis, unfortunately.
Thank you.
Thanks for that, Chris. we're running till 2:45, so if anyone has any other questions, then please do take yourself off mute. Okay, I think we're done. If you do have questions for Amy or want to have an informal chat with her about anything at all, then her details are on the screen there. We will forward you the slides, so you'll have Amy's contact details. You can check out us at the various websites there, of course. We'll send you the recording as well. I think that's probably it from us. Thank you very much for joining, and we hope you all have a nice day.